the public agency may request the applicant to pay additional fee to the already prescribed fee to process and provide the requested information and to communicate the information to the applicant. If any public agency denies to provide information, then the applicant must be informed of the name and designation of the officer who denied the request, along with the reasons for such denial. Now, the applicant, rather it is not necessary for the applicant to give reasons for making the application, but the applicant may have to present the reasons if he or she is claiming for waiver of fees. Now, fees can be waived under certain circumstances. Now, fees for seeking information under the Act can be waived if they are, or if information is basically sought for certain cases. For instance, fee waiver can be claimed when the information is being requested for educational or scientific purposes or for non-commercial use of information, or if the disclosure that will be made is likely to contribute to the public understanding of government activities and is in public interest. Now, all requests for information which are made for commercially using the information will be charged, and they will be charged for the search of the information, duplication, and also for review of such documents. Now, let us look at what the law in United Kingdom is. Now, in the United Kingdom, the Office of the Information Commissioner oversees the operation of the Act. And the Act enjoins on the public authorities to adopt and maintain a proactive publication scheme for the routine release of information that is important, such as annual reports and accounts. Now, these publication schemes must be approved by the Information Commissioner, who is responsible for the enforcement of the Act and who also is responsible for handling all appeals on behalf of those people whose request for information has been refused. So, the Office of the Information Commissioner, it looks at how the operation of the Act is taking place, that is the implementation of the Act, and this office is also responsible to handle appeals under the Act. Now, what are the applicants required to do? The applicants must submit a written application, give details of the information that they are seeking, and the writing must be legible and comprehensible for future reference. Now, the public authorities are required to provide or deny providing information within 20 working days. Now, the counting for these 20 days would exclude the day of communicating to the applicant the fee payable and the day on which the fees is actually paid. So, the days on which the fee is paid or how much fee is required for this information sought, this communication, that time would actually not be counted within 20 working days. And there is an upper limit which is set, that is the upper limit is of 60 days, so the information must be provided within 60 days. And every refusal to grant information has to be a reasoned refusal. You cannot just refuse to give information, but you also have to give reasons why the information has been refused. Now, the applicant has 3 months to pay the fee from the date of communication of the same by the authorities. Without payment of the requisite fee, obviously the request would not be processed. Now, if the request to obtain exempt information is made, then the applicant are to be informed of their request being considered within 20 working days of receipt of request and an estimated time for providing the information sought. So, what are the exemptions under the UK law? We'll be dealing with that a little later. So, basically, the UK Freedom of Information Act also allows for information which are exempt to be sought. And when such an application is made by an applicant, the authority will give them a time and they will inform the applicant that whether their request is being considered or not within 20 working days. 20 working days of the receipt of such request, and they will also inform the applicant that what could be the estimated time for providing the information. So this provision is actually unique to the law in the UK. Now, in case where the cost of information sought exceeds a certain limit set by the authorities from time to time, then such information would not be provided under the Act, but under a different regulation if it provides for the same. All the three legislations that we have discussed make provisions for appeal if the applicant has not received the information that he had sought for, or if the applicant is not satisfied with the information received. Now, if we look at the Indian law, Section 19 of the Right to Information Act provides that an applicant can file an appeal before a senior officer of the PIO within 30 days. Now, who can actually file an appeal? An appeal may be filed by the person who has submitted an RTI application and who's been aggrieved because no response has been received, or the response received is unsatisfactory or incorrect. Additionally, even third parties or parties whom the information sought relates to can also file appeal under the Right to Information Act. Now, the appeals must be disposed of within 30 days and not more than 45 days after extension. A second appeal has to be filed within 90 days of the order to the Central or the State Information Commission, and a third appeal may be filed within 30 days of the order of the Central or the State Information Commission. Now, if we look at the law in the United States of America, internal appeal can be filed by the applicant, which needs to be decided within a period of 20 working days. Now, if the application is taking more than the stipulated time of 20 working days plus 10 working days upon the extension of time, then the applicant can file an appeal before a court of law. Now, the agencies are required to file a response to the court appeal within 30 days of service of the complaint, and the burden of proof is on the agency to justify non-disclosure of information. Now, even under the Right to Information Act in India, the burden of proof is on the PIO to basically prove that whatever information he has provided is adequate. Now, the court in US may take into consideration exempted information if the dispute relates to denial of information, and it can also take into consideration records of the public agency if the dispute relates to the waiver of fee. Now, in the United Kingdom, the appeal system is similar to the Indian Right to Information Act, and there is a 3-tier appeal system. The first appeal lies in front of the senior public authority. The second appeal lies before the Information Commissioner, and the third appeal lies before a Special Information Tribunal. Now, if there is the need of any further appeal to be filed, those appeals would be entertained only if there is a question of law involved. So you actually cannot dispute the information received after the third appeal. But there is no time limit set under the United Kingdom's Freedom of Information Act. However, if we look at the Scottish Freedom of Information Act, then those appeals must be settled within 40 working days, or rather appeals must be made within 40 working days. Now, the central government departmental guidelines state that simple issues need to be decided within 2 to 3 weeks, and complex issues must be decided within 6 weeks. In case the issue pertains to any kind of environmental information, then the appeals need to be dealt with expeditiously within a maximum time limit of 40 working days. Now, the Scottish Freedom of Information Act provides 20 working days of time limit to decide any appeal, including those pertaining to environmental information. So, if we look at the Scottish law, because that law applies to the British citizens living in Scotland, then they have a crisper, they have a shorter time duration for settling of or deciding appeals. Third, information relating to FBI and foreign intelligence or counterintelligence or international terrorism records. Now, if we look at the list of exemptions under the Freedom of Information Act of US and the Right to Information Act in India, it would be evident that there is much in common between the two countries. Now, since the Indian law came into force only in 2005 and the American law has been in existence since 1966, it may be concluded that the Indian lawmakers were influenced somewhat by the American model. But it is important to note that although the American list of exemption is far more detailed, the Freedom of Information Act limits the discretionary powers of the officials by placing some explicit limitations on their decision-making power by responding to requests for information by citizens. But on the other hand, when we look at the Right to Information Act and when we look at Section 8 of the Right to Information Act, it does provide some kind of flexibility or some kind of discretion to the public authority to decide whether it is in the interest or it is in the interest of the public that the information sought should be revealed, even though it falls under the exemptions listed under Section 8. So in that way, we can say that the Indian law has given more decision-making power to the authorities when compared to the Freedom of Information Act. Now, if we look at the law in the United Kingdom, we see that there are two types of exemptions. First, there is the absolute exemptions, and second, there are qualified exemptions. First, let us look at the qualified exemptions. Now, all qualified exemptions require a judgment to be made on whether the release of information will prejudice the interests specified in the particular exemption. Now, there is a name for this test which is called the prejudice test or the harm test. Now, it may so happen that sometimes only a part of the information contained in the document will be exempt, while not the entire record. Now, qualified exemptions are also known as balanced exemptions or public interest exemptions, and they are left to the judgment of the public authorities with whom the information is available to decide whether it would be in public interest to confirm what information it has, but not to release it. So it may agree that we have the information, but the discretion has been given to the public authority to not divulge or release the information. Now, there are 17 qualified exemptions which are divided into two categories or two subclasses. So, and there are two tests which are applicable to these two subclasses. First is the prejudice test and the class test. While the prejudice test denotes the judgment of the public authority on whether or not the information requested is prejudicial to specific interests included in a particular exemption, the class test means whether or not the information sought contains or furthers public interest. So these are the two tests which would be applied. Now, the prejudice test exemptions include the matters of the country's national defense, international relations, relations within UK, the country's economic interest, law enforcement, audit functions, efficient conduct of public affairs, health, safety, and commercial interests. On the other hand, the class exemptions include material which are intended for future publication, national security, investigations and proceedings by public authorities, the formation of government's policy, communication with the Queen, then information relating to the environment, personal information, legal professional privilege, commercial information such as trade secrets, and information relating to any private sector involvement with public authorities. Now, let us look at what are the absolute exemptions. There are 8 categories of absolute exemptions, and a request for information falling into any of these 8 categories will not require the public interest test or judgment of a public authority on whether the release of information will be in public interest or not. Now, such requests or requests for information which fall under the absolute exemptions can be rejected outright, and it also relieves the authority of the duty to confirm or deny that it has the information. Now, this is very interesting. So, under the UK law, if any information is sought from a public authority, it has to actually say whether they have the information or they do not have the information. But if any information falls under these absolute exemptions, then the public authority also does not need to conform with this requirement. So, they don't even need to inform the public or inform the applicant whether the information sought is with them or not. Now, the 8 absolute exemptions are information which is already accessible by other means. Now, for instance, some information which is available in the website of each agency or authority. That is not something that they will provide. Second, information relating to state security bodies such as MI5, MI6, court records. Now, these records are left through the discretion of the courts, so they will not be granted. There are absolute exemptions. Parliamentary privileges, including proceedings in both houses of parliament, much of which is routinely published, and transcripts, then background data supplied to various committees of the parliament, then information which could prejudice the efficient conduct of public affairs, personal data, because they are protected under the Data Protection Act and they are generally available to the person who is subject to the information. Information provided in confidence, the disclosure of which will constitute breach of confidence or actionable by the other party. So this is almost like information available in fiduciary capacity. Now, this exemption is particularly important in relation to commercially sensitive information which are provided by private suppliers. Now, information, the disclosure of which is legally prohibited. Now, there are certain prohibitions under this. For instance, the UK Human Rights Act of 1998 prohibits disclosure of certain kind of information. Then the Local Government Finance Act, etc. Now, a close look at the absolute and qualified exemptions of the Freedom of Information Act of UK shows that it has actually influenced the lawmakers in India when they had enacted the RTI Act. So we can see that the Indian Act has actually taken a lot from both these legislations. Now, 1966 was when the Freedom of Information Act in America was passed. Although the United Kingdom law was passed only in 2000, it does bear a lot of resemblance with the Indian law. The Indian legislation does not classify exemptions into absolute and qualified exemptions, nor the qualified ones into prejudicial and class exemptions as is done in the United Kingdom. But all exemptions which are mentioned in the UK Freedom of Information Act find their echo in the Indian law as well. And there are a number of provisions in the RTI Act that empowers the CPIO or the SPIO in each office to judge if public interest outweighs other interests in the information sought. If it does, then it can release the information. But under the UK law, as we have just seen, that if any kind of information falls under the absolute exemptions, the public authority need not even get into this. So they may even deny information that they do not also need to reveal that they have the information or not. So this was the discussion on the 3 laws in India, UK and the US on the Right to Information and the Freedom of Information Act.